Thanks, Mr. President. I'll keep this brief. I'll keep this to 5 minutes, but it is very important. I think you'll agree it's a very important.
Name and address.
David Black, Aspenwood Lane, Willoughby, Ohio. I know all three of you, and I appreciate your liberty-minded, conservative stance on philosophy and government.
Thank you.
I'm going to pass this. I'd like this for the records. What my topic here is to help us, if we can get a resolution from the county to apply to the General Assembly for redress of grievances to nullify a vaccine law which is unconstitutional. And I'll read off. I don't know who wants to put this in the record. And I have 3 copies for each commissioner.
If you could just give it to the clerk, please. Thank you.
Well, just the easiest way for me to discuss is just read this off. It'll just take 5 minutes. And I think it's important. I think you'll agree in today's world is very important. It's addressed to the Ohio General Assembly. I'll also send a copy to our new state senator from the area. No one might have lost his name already. But it's petition to the Ohio General Assembly for redress of grievances, Article 1, Section 3 of the Ohio Constitution. And I'm hoping the county, being an administrative arm of the General Assembly, can help facilitate this. Per the Ohio Constitution's Article 1, Section 3, we hereby, and I have 23 signatures, which I gave to the administrator over there, Kathy Russo. 23 signatures on this petition.
Jennifer Belcathy's out.
Oh, I'm sorry, Jennifer.
That's okay.
Thank you. We hereby petition the General Assembly of Ohio for the redress of grievances that the 1986 Childhood Vaccine Act violates the Ohio and the U.S. Constitutions. The right to trial, well, by the way, that Vaccine Act has taken away the right to trial, jury trial, if you're hurt by a vaccine. You have to go to a federal court. You cannot take your case to a jury, and the federal court would decide it, and I'll explain that in a little bit. The right to a trial by jury in civil cases is one of the most cherished rights held by citizens of this country. For example, the Declaration of Independence enumerated specific abuses and usurpations by the King of Great Britain, having in direct object the establishment of absolute tyranny over the states. One itemized case of abuse was, and quote, for depriving us in many cases the benefit of trial by jury. So it was important enough for the founders of this country to itemize that in the Declaration of Independence. Patrick Henry, a member of the House of the Virginia House on June 5, 1788, stated the following objection at the Virginia Ratifying Convention of the original Constitution, which contained no Bill of Rights. He said, the rights of conscience, trial by jury, liberty of the press, all your immunities and franchises, all pretensions to human rights and privileges are rendered insecure if not lost by this change. Again, reiterating the importance of trial by jury. The 7th Amendment to the U.S. Constitution states, in suits in common law, when the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of common law. Article 1, Section 5 of the Ohio Constitution states the following. The right of trial by jury shall be inviolate, except that in civil cases, laws may be passed to authorize the rendering of a verdict by concurrence of not less than 3/4 of a jury. Interesting word in that whole thing was inviolate. I had to look at my 1828 dictionary to remind myself what that word meant, and it's a beautiful word. It says the obvious things are uninjured or unbroken, but the neat part of that definition was unprofaned, unpolluted. Are you going to profane the right to a jury trial? Are you going to pollute the right to a jury trial? That's exactly what they did when Congress passed that law. They took it away. They didn't pollute it. They took it away. So the importance of we're getting in this petition is the founders knew how important a jury trial was. Patrick Henry stated, I'm not going to sign on to this Constitution without the Bill of Rights, jury trial being one of those things. And here we let Congress in '86 pass a law taking it away. Okay, next paragraph. Any law made by the federal government or the state of Ohio that violates this explicit provision in the Constitution is an illegal law and should be rendered null and void. In 1986, Congress passed the National Vaccine Act, which includes the National Vaccine Injury Compensation Program. This violates both the U.S. and the Ohio Constitution by holding the vaccine industry, doctors, hospitals, and administrators harmless from civil suit. The law eliminates the right to a jury trial. Under the VICP, that's what's mentioned above, once a petition is filed with the U.S. Court of Federal Claims, it's assigned to a federally appointed special master. The special master is judicial officer who examines the evidence and adjudicates the claim. No jury is used. Standard rule of evidence do not apply. Total compensation paid over the life of this program has been $3.3 billion. Claim payments are funded by a 75-cent excise tax on vaccines. This situation is exactly what our founders intended to prevent, as it's ripe for corruption by the powerful. So think about that. The entire vaccine industry, if they hurt you, if you take a vaccine and you're injured, you can't take it to a trial by jury, which Patrick Henry said, and the founder said, you got to have that to have a free country. No, you go to a federal master appointed by the federal government. He'll determine it all by himself, and if they decide to award you some money, it's going to come out of U.S. tax dollars. And by the way, the footnote I use here, Commissioner Young will appreciate this, and I gave the document there. The reference of the evidence behind these things, where I say footnote 1, comes from a letter to Honorable Ron Young at the Ohio House of Representatives by Elizabeth Molnar, staff attorney, January 14th, 2016. As when he was a state rep, he helped us try to pass laws which would maintain liberties in whether or not to choose the right to have a vaccine. So the last paragraph, we, the undersigned, therefore request that the Ohio General Assembly immediately strike down the unconstitutional provision of the aforementioned law that prevents trial by jury by declaring it null and void in the state of Ohio, and immediately reinstate every Ohio citizen's constitutional right to a jury trial should they be injured by a vaccine. And then some of you may have known, especially our law professor here, and probably all of you know where nullification was used way back in the 1700s by Thomas Jefferson and James Madison, and he justified it as a state's right. As we know from reminding ourselves of the Constitution, the 10th Amendment says any power not delegated to the federal government remains with the states. We all have to remember here, because the powers on high coming through CNN and Fox News will tell us we have no power, all the power is in Washington, and we're worthless. The states delegated power to the federal government. You guys are more powerful than the federal government. Only what you've delegated do they have authority to operate. So anything you did not delegate, they have no authority. And in the Alien and Sedition Act, Thomas Jefferson and James Madison wrote a very good write-up where the states nullified that federal law because it violated the U.S. Constitution. So I'm asking you, as our local representatives, our liaison to the state of Ohio, if you could pass a resolution from the county of Lake County, pass it up to the Ohio General Assembly and say, yeah, we do feel that this law has violated both the U.S. and Ohio constitutions, and we want to consider it null and void. I'd love to take questions if your thoughts on that.
For some backup information while we're here, do you have examples of other states that have done this?
On this particular law?
Yes.
No, I don't.
So this would be a first in the nation?
I don't know. I'm not aware. Unfortunately, it's been under the radar because up until the last 5 years, vaccines haven't been forced on people, so they've just sort of allowed to slide under the rug. But now, as you see, the mandatory vaccines are becoming more and more prevalent, and it's time that we just have to say no more. Yeah. And when you read Patrick Henry's Anti-Federalist Papers, they made it very clear that you take away trial by jury, the oligarchs will, this country will turn into a tyranny. And we can see it happening right here. I mean, look at how beautifully they've rigged the system. If I'm in the vaccine industry and I make some product that I don't care if it hurts you or not, because if it does hurt you, if you get allergies from my vaccine, if you need an EpiPen from my vaccine, if you get autism from my vaccine, I'm gonna make more money because I also own the drug company that'll treat the autism, that'll treat the EpiPen, that'll treat this. How beautiful would it be if I can be free of liability so we can just become zillionaires and have zero liability so the oligarchs can consolidate power. So we have to realize the only way to maintain freedom is to uphold what Patrick Henry and the founders said, and that's uphold right to a jury trial by a jury of their peers, because this system is so rigged. So rigged.
Commissioner Young, Commissioner Plechnik,
Any thoughts?
Well, the bill that I worked on was a little bit different than this, but it's the same theme. And that was simply that employers couldn't mandate the flu shot as a condition of employment.
Sure.
So just wanted to clarify that.
Yeah.
But this, I've got to look this over, and we should talk more about it.
Sure.
Thank you.
Mr. President, first I second what Commissioner Young says. This is something that I want to review. I agree in principle. I will say again that this issue, like the last, does relate to powers over the head of this commission. And so even what you're asking for is a statement. And we need to review and consider in terms of how a statement could be made, assuming that all the commissioners agree, and in a way that would be effective. Because ultimately, this is federal and state government. The commissioners are just an arm of state government. We actually are not the General Assembly, which would wield any powers reserved under the 10th Amendment. One thing that we often have debated is that unlike city councils and trusteeships, we don't have home rule in Ohio, so we don't directly exercise the state's power. We're simply arms of the state. So just that clarification, we're not the deciders. So the discussion that we're having right now is whether or not this is a statement, a non-binding resolution that might be made.
Absolutely.
I do want to note that the Federal Court of Claims, I can't resist a history lesson. It's dangerous when you give a professor a microphone. The Federal Court of Claims is actually a very interesting creature of federal law. I came to know Judge Fran Allegra, who was a judge on the Court of Federal Claims, was a graduate of Cleveland Marshall before I became a professor. And he gave a very interesting presentation on its history. But ultimately, remember our favorite general from the Civil War who loved burning down every town in the South? Does anyone remember the name? Sherman. General Sherman. He was so enthusiastic that he burned down everyone's houses. Whether you were Confederate, Union, your farm, your house, it was toast. And so after the war, Congress tried to make people whole. Not surprisingly, everyone turned out to be a closet Union sympathizer. Oh, I was with you from the course, reimburse me. So people would actually go to Congress and would make their case for why they were on the Union rather than the Confederate side and ask to be reimbursed for the damage that the good general did. And this was time-consuming and controversial. And if there's anything politicians hate, it's time-consuming and controversial. So they created the precursor to the Court of Federal Claims to deal with the burning down of the South from their favorite general, but it grew into the court we have today. It's not an Article III court. The judges do not enjoy life tenure. It's what we call an Article I legislative court. And in theory, the Court of Federal Claims, it's justified in its status, exercises Congress's Article I legislative authority. Justice Scalia, rest his soul, was not a big fan of this. And the tax court was actually based on the Court of Federal Claims. It's another Article I legislative court. And I'll never forget seeing him months before he passed away at the tax court judicial conference at Duke University, where Scalia said, "It's been a real honor to present here, but as I said in my dissent in Freytag, you're all unconstitutional. I'm out." Rest his soul. So just a little background of the Court of Federal Claims that we're discussing for those back at home.
Very good, sir. Thank you so much.
Thank you, Mr. President. Appreciate it.